Good evening and welcome to our third broadcast of the 2013 Form I-9 webinar. I'm your host, Alana Myers, and our presenter this evening will be Mr. F. Brandon Mallory. If you have questions during our presentation, you can text them and they will be answered by panelist Peter Conlon. Please feel free to interact. There will be a live Q&A session at the end of our presentation. Our broadcast will begin in approximately 8 minutes. Thank you. Good evening and welcome to our third and final broadcast of the 2013 Form I-9 webinar. We are so glad to have you with us this evening. Our presenter will be Mr. F. Brandon Mallory, and I am your host, Alana Myers. And our panelist, Peter Conlon, will be answering your text questions during the presentation. After the presentation, we will have a live question and answer session. So feel free to participate and enjoy the broadcast. I'm going to turn things over now to our presenter this evening, Mr. F. Brandon Mallory.
Well, good evening. Welcome to our third and final installment, at least for now, of the 2013 Form I-9 webinar. This has come about because of the change in the form that was introduced just a few weeks back on March 8th, and just our desire to keep our clientele as well as the industry updated on this very important topic, and that is I-9 compliance. We're Agri-Placement Services, and we are a primarily staffing, consulting, and labor law compliance company. We're based in central western New York, actually the Finger Lakes region, really beautiful this time of year. And we're going to get right into this. We've got quite a few slides to go through. You can also chat your questions, and we have Peter Conlon available to answer those in writing via text. So just follow your screen there, and where it says type in a message, you type it in and send it, and our colleague Peter will answer your questions. We're going to cover the basics of I-9 completion. We're going to talk about some prohibitions and various unfair documentary practices, discrimination kinds of things, penalties. We're going to talk about what happens when ICE comes to visit you. We're going to really get into how to avoid having to go through an audit to begin with. We're going to talk about how to correct your I-9s, and at the very end we're going to talk about some things that are somewhat unrelated to I-9 compliance relative to labor law compliance. In June of 2012, the Department of Homeland Security announced their enforcement guidelines. And they basically indicated that they were going to strategically enforce I-9 compliance targeted at employers as opposed to employees. And in 2012, there were actually 3,000 notices of inspections that were issued, $10 million in fines, and 238 company managers were actually arrested. These numbers came directly from the division of ICE, and they're relatively current. We don't have any data on actual companies that were debarred, but we understand that as a result of these audits, there are actually companies that were debarred from doing business. Well, how do you protect your business? Well, we know that an I-9 audit can be the foundation of a raid, a civil money penalty, and even criminal sanctions. You want to make sure that your I-9 compliance programs are in place and up to date. I mean, there should be, your operation should have a practice of how I-9 forms are handled. You should be conducting regular internal I-9 reviews. In other words, once there's been a period of time that has elapses, and we're thinking, depending upon your operation, at least annually, you want to pull those I-9 forms out and review them and remedy any identified errors. We also recommend that you use an outside company to help you with that process. And the reason that we recommend someone from the outside rather than someone internal is that many times somebody from the outside will see errors that you committed that you perhaps may be too close to. You know, just like when you're writing a paper or a letter, you may have errors that you see, and because you know what you intended to put there, you continually overlook the same error. But when you have a fresh set of eyes look at it, many times they catch errors that you do not see. So we recommend an outside company to come in and help you with the process. And we can also help train your personnel, your company officials, to know what to look for during the course of an internal review. Well, what are the requirements? Well, as I mentioned earlier, on March 8th of this past year, U.S. citizenship and Immigration Services, which is a division of the Department of Homeland Security, issued a new Form I-9. And it went from a single page, which is what it has always been since the Act was enacted in 1986, to 2 full pages. And it went from 4 pages to general instructions that were given with the form itself to 7 pages. So now you have what is essentially 11 pages of form and instruction that are supposed to be given to every new hire. Anybody that was hired after November 6, 1986 is required to have an I-9 form on file. So any employee that you have currently that was hired after that date is required to have a current I-9 form on file. Even if you as an owner, if you receive a W-2 form and you did so after November 6, 1986, then you're also required to produce an I-9 form for yourself. And if you haven't done that, do it now. Certainly better late than never. And our experience has been that, generally speaking, these guys aren't really trying to be real hard. They're trying to get compliance. And even if after the fact you go back and complete the I-9 form that you should have done as owner many, many years ago, many times they'll accept that, understanding that it was just an oversight and not your intention to circumvent the law in any way. Well, these other versions, the 8709 as well as the 2209 versions of the form will be obsolete in just a week. On May 7th is the end of the 60-day grace period. So after May 7th, up until May 7th, you can use these other versions, but after May 7th, the current version of the form, the one dated 3/8/2013N, will be the only legal form that you can use. Section 1 is completed by the employee prior to the start of work, but after the job has been offered. And then Section 2 is completed by the end of the 3rd business day after the employee starts work. And we're going to talk a little bit more about specifically what is meant by prior to starting work and by the employer by the end of the 3rd business day. One thing that's worth noting here relative to changes that took place on March 8th, concurrent with the reworking of the I-9, they also reproduced what they call M274 Employer Handbook. And it is the instructions that are used to complete the form. This particular handbook is, I believe, 63 or 64 pages long. And it talks in detail about all the specificity around completing this 2-page form, I-9, that you're required to keep it on file. What's noteworthy about the Employer Handbook is the change in the title. It's called the Employer Handbook. The subtitle, up until this time, the subtitle was Instructions for Completing Form I-9. Well, they changed that subtitle from Instructions for Completing Form I-9 to Guidance for Completing Form I-9. And we think that's significant because instructions obviously has a connotation that it's telling you exactly how something should be done, where guidance is just that, it's guidance. It's not specific. But with that said, there are very, very specific requirements that you're required to adhere to as an employer. So we think that change in language in terms of what they call the handbook is significant. Okay, employee must complete Section 1 before work commences, but after the job has been offered. So Section 1 has to be completed before work begins, but after the job has been offered. It doesn't matter how long before the job begins that they complete it, but it does matter that the job has to be offered first and has to be accepted by the employee. And the reason for that is there's information in Section 1, such as the date of birth, which an employer is not privy really to have until after the job has been offered. You have no right as an employer to know what somebody's date of birth is before you hire them. Therefore, Section 1 cannot be completed prior to the job being offered. But at the same time, it has to be completed before they begin work. So sometime between the time that you actually say, okay, you're hired, and the time that work actually begins is the time that Section 1 has to be completed by the by the employee. And it's very, very similar to the previous versions of this form. It's been formatted differently, and there are a couple of new fields, but it's not altogether different. As you can see, there's an email address field. This is new, as well as a telephone number field. These were not a part of any other prior versions of the form. Another thing that I'd like to bring your attention to is at the very top of the form it says, read instructions carefully before completing this form. The instructions must be available during completion of this form. So they're telling you that the 7 pages of instruction, there's actually a little booklet. I'm not talking about the employer handbook for instructions. What I'm talking about, the form itself, is that really there's only 2 pages that are actually written on, but there's 7 pages of instructions that go along with that, including a list of acceptable documents. So all 9 of those pages are supposed to be presented to the employee prior to them completing the form. And there's also an anti-discrimination notice that I wanted to bring your attention to. It is illegal to discriminate against work-authorized individuals. Employers cannot specify which documents they will accept from an employee. The refusal to hire an individual because the documentation presented has a future expiration date may also constitute illegal discrimination. So I think it's significant that this is at the very beginning of the form. So obviously they're very concerned about discriminatory practices that employers might be involved in. So you have to be very careful. You know, on the one hand, you're required to not hire anyone that doesn't have a legal right to work in the United States. But on the other hand, you can't ask the wrong questions. You can't ask inappropriate questions. Or you can't require specific documents and other kinds of discriminatory practices, or you'll be in trouble by another agency called the Office of Special Counsel, and they investigate discrimination-based hiring. Again, Section 1 is completed by the employee. The Social Security number, believe it or not, in Section 1 is not a required field to be completed. It is asked, it is requested, but for I-9 purposes, it is not required. This does not mean that you don't need a Social Security number for someone to hire someone, because there are other employment-related documents where it is required. But for I-9 purposes, the Social Security number is optional unless you're involved in the E-Verify process. Section 1, employee must check the box attesting to authorization to work in the U.S. If they're an alien, either authorized to work until a certain date or a permanent resident, they must include their alien registration number. And depending upon what their visa designation is, there could be additional fields in the second part of Section 1 that the employee must complete. The employee must sign and date the form, and if the employee has assistance completing the form, then there is a field for the preparer and or translator. So the employee will attest as to what their immigration status is by checking one of these 4 boxes. Depending on which box they choose, there could be a alien registration number required or Form I-94 admission number here, as well as their foreign passport number and country of issuance. Generally speaking, we don't require these documents. These aren't the documents that we're seeing. What we're generally seeing, and probably most of you are seeing, is this box here being checked, which is lawful permanent resident, in which case the only thing that's required is the alien registration number. And then, of course, the employee signs, dates, and if they had any kind of help, including you, with completing the form, then you would be required to complete this box of information as well. Nothing is written in this area right here. This is a space that will be used for future technology, the way we understand it. Oh, incidentally, there is a Spanish version of Form I-9. It cannot be used by U.S. employers, but it can be used by U.S. employers as a template. It can be used as a translation guide, if you will. because it is identical to the English version of the form, if you have an employee that speaks only Spanish, the Spanish version of the form could be used as a translation guide or a template to help the person understand, who reads only English, what is being said on the English version, only reads Spanish, can understand what is being said on the English version of the form. But in the United States, the form has to be completed in English on the English version of the form. The Spanish version of the form was created for the Commonwealth of Puerto Rico only. We talked earlier that we were going to talk about what is meant by the end of the third business day. So the employer, at this point, must receive documents from the employee that authorize the employee to work and also identifies the employee. Sometimes this could be one document or a combination of documents. The employer has until the end of the third business day, after the employee starts to work, to complete Section 2. And they define after the third business day as Thursday if a worker begins on Monday. So if a worker begins working on Monday, the employer has until the end of Thursday to complete Section 2. The employer must examine the documents that are presented, and they must determine if the employee is then authorized to work. I want to draw your attention to something that frequently is overlooked, and that is this great big "or" that's right there. You're actually requesting from the employee a document from List A or a document from List B, and C, not and. We frequently see a document from each column, where it is a List A document or a List B and a List C document, not and. The employee then offers to the employer documents of his choice once he's been given this list of acceptable documents. There are not any new documents on this list from the previous version of the form. They've explained things a little bit differently, but there aren't any different documents. Once the employer has been presented with the documents that identify the employee and authorize the individual to work in the United States, the employer then completes this section of the employer review and verification. I also will bring your attention to this area here, which says employee last name, first name, middle initial. So this is the employee that you're hiring from Section 1. So you write his name, or her name, of course, in this section of the form again, in case pages 1 and 2 are separated. And then the employee will present to you either a list from a document from List A or a document from List B and a document from List C. And then you will complete these various fields accordingly. The only difference really in this section, other than formatting differences, is it's added a full third field under List A. And the reason for that is there are combinations of documents that are considered List A documents that have various titles and numbers. And there is some instances where actually all three of these fields here are used in combination for the employee to meet the I-9 requirement. Then the employer certifies. They insert the date, name, and title of the employer representative, business name and address, and they sign and date. And they also complete a very, very important part of the form which frequently is not done. So here's the second part and the last part of the employer certification, where they actually sign, date, title, last name, first name, name of your business, address of your business, city, town, state, zip, and very importantly, the date work began we frequently see this left blank. Frequently. It may be the most common error that we see as we review these I-9 forms. We also want to bring your attention to a significant change in this section as well, where the employer is attesting under penalty of perjury that to the best of his or her knowledge, the employee is authorized to work in the United States. This is new and a very, very, what we believe, significant change in what the employee is attesting to, what the employer is attesting to. Heretofore, they were attesting that they examined the documents that were presented to them and that they appear to be genuine and to represent the employee that is named. And that was all that was attested to. You weren't attesting that, to the best of your knowledge, you believe that the employee is authorized to work in the United States. You're signing and you're swearing to that. So to us, that's a significant change, and it's worth noting. Part of the certification process is that you have to determine that the documents are genuine, reasonably appear to be genuine. Excuse me, you don't have to determine that they're genuine. That's a very, very important misstep on my part. You don't determine that the documents are genuine. They have to reasonably appear to be genuine to you and to relate to the individual that's giving them to you. And obviously, they have to authorize the individual to work. They have to be originals and not photocopies. Several times throughout the employer handbook, it is mentioned documents have to reasonably appear to be genuine and to relate to the individual that's giving them to you. And that's what the key is. They have to appear to be genuine to a reasonable person. As you look at this document on the screen, to a reasonable person, it appears to be genuine. So it's already met that first criteria, okay? Does it appear to be genuine? To us, this does. Now, does the document relate to the person that's giving it to you? Well, if a 6'5" black Jamaican hands you this document with that picture on it, although it may appear to be genuine, it obviously does not relate to him. So it does not meet the relate to part of the requirement. In a less extreme example of does it relate to the individual, look at the date of birth here. It says January 1st, 1992, which makes the individual 21 years old as of today. Well, if a 60-year-old man or someone that appeared to you to be 60 years old handed you this document, although it appears to be genuine, it does not relate to him and you could not accept it. There is a re-verification Section 3 part of I-9. This is used by seasonal employers quite frequently that have employees that return to them. If an employee is authorized to work in the United States and their work authorization will expire, you have to re-verify. With permanent resident aliens, even though it is a work authorization document as well as an identity document, you do not re-verify a permanent resident alien, and most of the farm workers that come to work for us and with our farms are permanent resident aliens. So we do not use Section 3 to re-verify. We do not re-verify their document. When it expires, they're still authorized to work if the document was not expired when they came to work, when they began work. But there are instances where employees leave and they come back, and Section 3 can be used. There are also instances where there are specific work authorization documents that do expire that you must re-verify. The permanent resident card just is not one of them. And as long as it's within 3 years of the time that they're hired, you can use the same I-9 form again. You don't have to complete an I-9 form all over again if it's within 3 years of the time that the person is originally hired. And this is what Section 3 looks like. If, for instance, someone was working for you in the past and their permanent resident card, for example, hadn't expired, and within the 3-year period they came back to work for you after having left, you could rehire them without having to complete a new I-9 form. You could just take out the old I-9 form, put in the new date of hire, and you would sign and date and print your name, and that would be sufficient. Obviously, if their work authorization document or their permanent resident alien card had not expired. If it did, then they'd have to present another document. This could also be used in the instance of seasonal employers that have individuals working for them for a season and then they come back the next season. Photocopy rule, worth noting, documents may be photocopied, talking about the documents that individuals present to you, identifying them and authorizing them to work in the United States. May be copied, but not required. If you photocopy documents, obviously you must also complete the I-9 form in its entirety. Some of the benefits of photocopying documents is that they can be used to correct errors later on, and they also show good faith in that you're trying to comply with the law, because if you have copies of the documents that were used to complete the I-9 form, you obviously have additional proof that you indeed saw these documents. There are a lot of other reasons why you may not want to make copies. One of them is if you make copies of one of your employees' documents, then you have to do it for your entire workforce, any new hires. You have to keep those documents, copied documents, with the Form I-9, and you also have to submit the copies of those documents with your I-9 forms in the event of an I-9 review by ICE. Another reason why you may not want to keep them is they could be used against you. If there's information that perhaps they perceive should have been seen by you at the time that you hired them, they have a copy of that document that say, hey, maybe you should have noticed that. You should have noticed that the birth date was a little bit off there. You should have noticed that, you know, the guy looked a little bit different than what's on the picture. You know, so there's pros and cons, and you have to look at what makes sense for your operation. One thing that I didn't mention here, that if you fail to copy all the documents of all of your new hires, then you could be guilty of discrimination if you only make the photocopies of few clients, few of your employees, excuse me. Retention requirements. Once employees are terminated, you must retain I-9 form for at least 3 years from the date of hire, or at least 1 year from the date of termination, whichever is later. What that means is if you have an employee that worked for you for 20 years, and then after the 20-year period, the relationship with the employee ended, you would have to hang on or retain that I-9 form for an additional year. So you would have had that form for a total of 21 years. So you met the requirement of having it for at least 3 years, and you met the requirement for having it for at least 1 year after the date of termination. Once that requirement has been met, you're no longer required to retain the form. Another example of at least 3 years from the date of hire and at least 1 year from the date of termination is you have an employee that works for you for 1 year. How long do you keep the form if the relationship between you and the employee ends after 1 year? Well, in that case, you'd have to retain the form for an additional 2 years, for a total of 3 years, in order to meet the at least 3-year requirement. We recommend that once the retention requirements have been met, that you purge or remove all those documents from your files. Immigration Reform and Control Act of 1986 is the act that created the I-9 process. You cannot hire knowingly any alien not authorized to work in the United States. You can't hire any individual without verifying their identity and work authorization. And you cannot continue to employ an individual if you know or should have known that he was not authorized to work. There are also discriminatory or discrimination provisions, anti-discrimination provisions. That includes discrimination against citizenship status, immigration status, and national origin. Documentary practices that are unfair. You can't ask for specific documents. You can't refuse documents that appear to be genuine. You can't pick and choose or tell the employees which documents to present. That is their choice. There are errors that we commonly see. We review and look at these I-9 forms quite frequently, and we're going to talk very briefly about some of the most common ones in Section 1. The first and the most common one that we see is that Section 1 is completed after the employee begins working. Section 1 must be completed on or before the start of work. And obviously, if that's not done, it's not correctable. Other errors are not checking the box indicating as to what their status is regarding authorization to work in the United States. Employees fail to fully complete the citizenship attestation box, and the employee did not date and sign. All those are correctable errors. Section 2 also has some very common errors. No start date listed in the certification box. Issuing authority and document number is frequently missing. Many times we see too few or too many documents listed in Section 2, or the employer didn't sign the box, or the employer certification is incomplete. This is an example of a I-9 form completed by a U.S. citizen that has been done correctly. This is a permanent resident, which is the most frequent status that we encounter. In this particular case, although the permanent resident alien box is checked here, and the individual listed his alien registration number, when it came time for him to complete Section 2, he submitted to the employer a driver's license and Social Security card. This is a good example to talk about unfair documentary practices. So although this individual is a permanent resident alien, you as the employer can't request to see his permanent resident card. You present the list of acceptable documents, and he chooses what he wants to present to you. And in this case, he chose a driver's license as an identity document and a Social Security card as a work authorization document. You can't ask for anything else. He's met the I-9 requirement. You as the employer, sign, date, indicate your title, in the rest of the field required by the employer. Here's a third type of status. This particular alien is authorized to work until a certain date. Here you see the use of the various fields in Section 1. He indicated his I-94 admission number as well as his foreign passport number and the country of origin. Same thing in Section 2. This is just a look at what the I-94 card looks like. If you use H-2A, you'll see this. This happens to be an H-1B visa designation, a specialty foreign worker. They have, actually this is a two-part document. They have a departure as well as a arrival part of this I-94. Here's an I-9 form that was not completed correctly. Are you able to identify some of the errors as you look at this form? Look at Section 1. What's missing? Section 2. What's wrong? Here are the errors identified. Well, during the course of an internal audit, how would one correct these? We like to put at the top of the form per self-audit. The reason that we do this is we want to identify to any inspecting officer from ICE or the U.S. Department of Labor that we have corrected this form. This isn't anything that we're trying to hide. We're not trying to go back and present this form as if it were not corrected after the fact. No, we realize that we made some mistakes when we first did it, and now we're correcting those mistakes. The employee neglected to check the citizen attestation box. So then the employee goes in, checks the box, initials and dates the change. Same thing in Section 2. The employer had too many documents in this case. So we cross off the extraneous U.S. passport. We write per self-audit, probably better put up here, per self-audit. And then right here where the correction is made, Nancy Sooner, the employer here, initialed and dated the change that she crossed off the passport. She initialed and dated the change that she filled in the additional driver's license information as well as Social Security information. And this is the way such corrections are made legally. Things to remember. As we mentioned, permanent resident alien cards are not re-verified. This is something that we always see. We see employers want to go back after they've hired their permanent resident alien and they see that their document expired and they ask for another one, and they're not required to do that and could be guilty of discrimination for doing so. Sometimes there's a delay between the time that an employee has a valid document and one that expires before they actually have the additional document issued. So permanent resident cards are not re-verified. You can never ever accept an expired document under any circumstances, really, either a List B document or a List A document. It has to have a valid date at the time that they're hired. But if a List B document or resident alien card or a U.S. passport or U.S. passport card expires during the course of an employee working for you, you do not re-verify. You do not ask for an additional document later on after that expiration date comes and goes. Social Security cards that are marked not valid for employment or only valid with DHS authorization is not an acceptable List C document. This type of Social Security card you may see. This is not a List C document. You notice a Social Security card that's not been restricted in any way is a List C document. One that's been restricted in this manner is not a List C document. It's really not valid at all for I-9 purposes, actually. It has to, a person that has this kind of Social Security card would have to have some other kind of authorization to work in the United States as well as an identity document. This kind of Social Security card would not be acceptable. Well, you want to plan for an audit under any circumstances. There's always a possibility that you could get a visit from ICE or the U.S. Department of Labor. Those are the two main agencies that may ask to look at your I-9 forms. We recommend that you conduct periodic self-audits. Make sure that your staff knows how to properly complete Form I-9. Let us help you or let someone help you do that. Once your staff is trained, then you can periodically do self-audits. We recommend that you keep I-9 forms in a separate binder and not in personnel files. You have a binder for your current employees, and then you have a separate binder for your past employees that are within the retention period. And those are the two binders that you have, not to be mixed in with your other personnel files that might have W-4 information, may have work agreements in there, could have a number of other documents that you keep in their personnel files. You want to keep your I-9 forms completely separate. You want to purge I-9 forms whenever possible. You don't want to hang on to forms that could have errors on them that could get you into trouble. So once they meet that retention time frame, you want to get those out of your system. And by all means, prepare your staff in the event of a visit. If somebody from ICE shows up, how would anybody on your farm react to that? Anybody in your operation, what would they do if ICE, no time to panic. There should be a very specific protocol that everybody should follow. And so you want to make sure that everybody knows what that is. One of the first things I think you would teach them is who on the farm should ICE be talking to. There should be one person, not just anybody. There should be one designated person, I would think the owner or manager, that ICE should talk to if they come and they want to take a look at your I-9 forms. They have to give you 3 days notice, okay? A notice of inspection is a letter that indicates that their Immigrations and Customs Enforcement, and they want to review your I-9 forms. They tell you that you have 3 days to present the forms to them. You can waive the 3 days, but obviously we don't recommend that. It is acceptable to keep I-9 forms electronically as long as the information cannot be accessed by individuals and can't be corrupted in any way. Personal appearance to give testimony or turn over your documents may be required. They may ask you to bring the forms to them. That's actually common. It really should happen one of two ways. They should either come and get the forms and review them at your place of business, or you should take the forms to their headquarters. You should never, ever give them your original I-9 forms and allow them to leave with them. You're not required to do that, and it would be very unwise to do so. If I had a choice, I think I would rather bring my forms to their headquarters rather than have them at my operation, but that's your choice. You may turn over copies of your forms to them. That's your choice, but under no circumstances would I relinquish my original I-9 forms to any inspecting officer. You're not required to do so. Certainly a subpoena or warrant is not required for an I-9 inspection, only a notice of inspection giving you the 3 days to come up with the forms. Sometimes the forms are at a different location. The idea is to just cooperate. Okay, you're not trying to give anybody a hard time. If forms are going to be someplace else and they're going to come back and look at them, okay, you don't want to come to the farm, Mr. Iceman. You want to come to this other location. Here at my home is where my I-9 forms are, and this is where you need to come to review them, kind of thing, rather than try to give these guys a hard time. It's been my experience that they're really not that difficult to work with. That generally speaking, for the most part, just trying to do the job that they've been paid to do. Providing forms to ICE. Notice of inspection requires employer to produce documents for review. It may not be required to turn over originals or copies of I-9 forms. You really don't even have to turn over copies. I don't know. That's your decision. You might want to consult legal counsel about that. They have a right to look at the originals. That I know. In terms of, do they have a right to have copies? I don't think so. But I frankly don't see anything really that wrong with giving them copies. But you consult your immigration lawyer on that one. They can ask to not only look at your I-9 forms, but they are going to want other things because they want to match your I-9 forms with your payroll records. So they're going to ask for an employee listing, wage reports, other payroll data, any Social Security mismatch correspondence you may happen to have. They're going to want to know your business name, number, Social Security numbers, or employer identification numbers, and that sort of thing. If you receive a search warrant, on the other hand, there is no 3-day notice required. It's a very, very different situation. You certainly want to consult legal counsel immediately. As a matter of fact, you probably want to have previously consulted with an immigration lawyer, so you have someone that you know who's conversant in immigration law that you can bring to bear if there's a search warrant issued by ICE. You want to keep track of kind of what's going on. You want to cooperate, obviously. You want to be sure that, you know, they adhere to whatever the terms and conditions of that warrant are. They may not have access to your whole operation, but only certain areas. So again, it's important to have a lawyer to stand by. You can get into a significant amount of money, obviously, depending upon how many times, how many different violations there are, and how serious the violations are. Anywhere from $110 to $16,000 is a pretty wide range. There are also criminal penalties that are significant. Electronic verification system. Dark green are all the states that are required to use E-Verify. The blues are various degrees of E-Verify. The bar graph here shows an exponential increase in employers that are using E-Verify. Over 400,000 employers as of March 2013. E-Verify is a collaborative effort between the U.S. Department of Homeland Security and the Social Security Administration. Their databases cooperate with one another, and an individual is determined to be authorized to work or not work in the United States almost within seconds. An employer signs up for this, their software on their computer. Individual employers feed this information into their computer, and the results are given almost in seconds in most cases, and it's really fairly accurate. We understand that if there's any kind of immigration reform, there will be E-Verify that will go along with it. This is pretty much, if there's any kind of immigration reform, any kind of program that passes, and we're certainly very, very hopeful currently, there'll be E-Verify that will come with it. Well, why did you receive a notice of inspection? I-9 audits are not random. They're caused by specific triggers, and those triggers or whatever caused you to be given a notice of inspection in most instances can be identified. One of the biggest triggers is your industry. You're a farmer. Farms are targeted. That's a fact. Despite what the powers to be might say, we know that farms are targeted. Sometimes your neighbors, you know, because you you maybe dumped a little manure on the street, believe it or not, or whatever the case may be. Disgruntled ex-employees, immigrant employees, as well as U.S. employees that have an axe to grind with their fellow workers or with you. Workers that violate various city, state, and county laws. Any kind of riding around in uninspected motor vehicles or uninsured motor vehicles or tail lights that are out or a loud muffler or any kind of vehicle is almost a magnet for a regular local county sheriff or town policeman who in many instances will contact Border Patrol or ICE. Also, violation of labor laws. There are a whole series of labor laws that farms are required to comply with. And we have found that not adhering to these laws can also be a point that triggers a visit from Department of Homeland Security. U.S. Department of Labor Wage and Hour Laws, Migrant and Seasonal Farm Worker Protection Act for those of you that are seasonal employers, the minimum wage law. There are nuances to that, you know, in terms of individuals being paid salary and at what point, you know, is that minimum wage not being met, those kinds of things, various record-keeping requirements, child labor laws, myriad of various posters that you're required to have up. If the U.S. Department of Labor or the state wage and hour individuals visit your operation, many times this can trigger a subsequent visit from ICE. Work agreements, dairy farms frequently are not aware of many of these laws. They've not been nearly as targeted as seasonal operations in New York State. I'm not sure about other states, but in New York, seasonal operations are much more likely to get visits from federal as well as state wage and hour people, and therefore they're kind of more prepared to have a better understanding of these laws than full-time dairy operations in many instances. And of course, I-9 compliance is a big one. And we offer a compliance review for those of you that need some help with complying with these various laws. And these are some of the things that will be included in our compliance package. If you become a member of APS, we'll spend 4 hours on your operation. We'll go over these as well as of many other Department of Labor laws as well as requirements based on I-9 compliance. Included with that package are live webinars such as this. In New York State, we'll even arrange an OSHA training session for your farm on site, safety training of your employees and those kinds of things. There'll be exclusive pages on our website that only APS members can access. So if this is something that you're interested in, please let us know. We've been in the business for a long, long time and know quite a lot about labor law compliance and other types of things that, you know, farms are many times too busy to even worry about. So let us know. Been great talking with you. Feel free to hang around for our Q&A session, and in the future contact us if we can meet any of your labor needs.
Thank you, Brandon. That was a wonderful presentation. I have just a couple questions for you from some of our audience members. One audience member asked, if I have a worker who goes back to Mexico for 6 months or a year and then comes back to work for me, do I need to fill out the new I-9 or re-verify?
The safest answer to that is yes. And probably the main reason why I say that is in many instances you may not have to fill out a new I-9 form if you're rehiring someone that worked for you just 6 months ago, if it's within a 3-year period. But if the I-9 form has changed or the individual's document has expired, in many instances it just makes sense to just do another I-9 form even though you may not be required to do so. So my recommendation for you is if someone worked for you for 6 months and came back, unless you're really well versed in I-9 compliance, I would just recommend doing another form. The only time that this really doesn't make sense is when there are individuals that have worked for year after year after year, seasonal employers, and you're hiring maybe 25 or 30 or 40 employees yearly. It may not be worth it to you every year to do every form over again. In that instance, you can save a lot of time if you're not required to use Section 3 of the I-9 form and re-verify. But we recommend in most instances to just do the form over.
Thank you, Brandon. Those are all the questions I have. Did you have any more comments for our audience tonight?
Only again, I would just reiterate what I said earlier about the triggers that cause an audit. We've been in the labor law compliance business for the better part of 15 years now, and prior to APS beginning, we worked for the U.S. Department of Labor. And so we've been working with farms for a long time in this area of I-9 compliance and immigrations and reviews and all of this stuff. And most of the time when there's any kind of immigration investigation that we've had any part in, I would say without exaggerating, 75% of the time, if not higher, it involves some kind of vehicle. Either a car, a four-wheeler that's on the road, and if not that, then some other kind of violation of some other kind of law. In other words, if the guys stay out of vehicles and stay out of trouble, more often than not, you're not going to have any trouble with any kind of ICE I-9 audit. And so that would be probably the most important thing that I could leave you with, is to make sure that your employees, keep their nose clean, and you should be fine.
Thank you, Brandon. We appreciate your presentation tonight. If you have any questions about labor law compliance or have staffing needs, feel free to contact Agri-Placement Services at www.agri-placement.com. Thank you for attending our webinar and have a great week.